All right. Good morning, everyone. My name is Annika Lee, and I am the Public Affairs Coordinator at the Digital Supercluster. And I'm pleased to welcome you to our webinar, How IP Can Enable Your Business Strategy. Before we get started, we respectfully acknowledge that in Canada, we live, work, and learn on the unceded traditional and ancestral land of Indigenous people. As myself and much of the Supercluster team are based in Vancouver, British Columbia, we are gathered here on the traditional ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh people. And we encourage you to take a moment to acknowledge and let us know in the chat the traditional territory that you are joining us from. As a reminder, this webinar is being recorded and we will distribute it to all the registrants afterwards, as well as post it on our website. If at any point you have a question during the session, please type it into the Q&A chat and we'll address them towards the end during the Q&A portion. Now I'd like to hand it over to our IP manager, Jen.
Thank you, Annika. Bonjour, everyone, and welcome. It's wonderful to have so many joining in from across the country in this installment of the IP Focus series that we're running. Whether you're new to the Supercluster or our returning face, we're thrilled that you're able to join us for this Power Hour. Next slide, please. In the shift towards an intangible-based economy, the rise of intangible assets such as data, software, and patented technologies highlight the importance in strategically aligning your IP assets with achievement of your business goals and effectively leveraging those assets to gain a competitive advantage and drive revenue and growth opportunities. For innovative SMEs, this awareness of the value of IP rights is vitally important. SMEs with at least one registered IP right earn 55% more revenue per employee than those with no registered IP. And for SMEs that own both patents and trademarks, for example, generate 75% more revenue and grow faster than those with no registered IP rights. However, simply being aware of or holding IP does not mean that those assets are being effectively managed, and not everyone comes with a starting position of having a robust IP portfolio of cutting-edge intellectual property. And therein lies the importance in building and implementing an IP strategy and building and using IP to build out investment interest, irrespective of industry and organizational size, and availing yourself of some of the resources that can support you. Over these next 60 minutes, we'll cover items that include key considerations when creating IP portfolios and strategies, how an IP strategy increases your company's value, and practical guidelines for working with experts. As Annika mentioned, we encourage you to post your questions in the chat, and we'll be weaving in the Q&A through the talk. Next slide, please. A foundational component of the Supercluster is collaborative innovation, setting the framework for projects that address cross-country challenges while creating technology products and services that can scale across industries and ultimately across the world. The Digital Supercluster's IP strategy supports the development, ownership, and retention of Canadian IP through a number of vehicles, and informational sessions with industry thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing today's panel. Please join me in welcoming Erin Pisko and Niraj Gupta. Erin is VP of IP Strategy at the Innovation Asset Collective, a not-for-profit assisting Canadian SMEs in the data-driven cleantech sector to better leverage IP to grow and scale, and provide strategic leadership centered on innovation strategy to member companies, with the objective of building IP roadmaps aligned with business objectives and an IP-literate workforce. She is a registered patent agent with decades of experience working both in-house, building out ecosystems for innovation, and at top-tier Canadian law firms, assisting companies from diverse industries in building and transforming their innovation strategy. Erin's passion is to help companies of all sizes find value in going beyond the aha moment of their initial discovery and building on that moment to drive value in the everyday aspects of business. And fun fact, she was nationally ranked cross-country skier and competed not only across Canada, but as well in several European World Cups. Niraj is Chief Strategy Officer at Calgary-based Attabotics, the world's first 3D robotic supply chain system, reducing a company's warehouse needs by 85%, and has been adopted by major brands, including the luxury department store Nordstrom and other retailers across food and beverage, apparel, and home goods. He is an angel investor and an expert in global startup ecosystem building, strategy, startup investment, intellectual property, and innovation management and technology commercialization. He has mentored over 100 startups globally and angel invested in a number of them. Niraj is also senior mentor and visiting faculty in several engineering and MBA programs and is the author of Creating and Safeguarding a Strong Intellectually Property Portfolio. We have a powerhouse hour ahead of us, and without further ado, I hand it over to you, Erin and Niraj.
Thanks, Jen. I love your intro. That's so great. I think let's dive right in. And Niraj and I have a few things we'd like to get through. As Jen said, we'll really try to monitor the Q&A and incorporate things as we go. But I wanted to really kick things off with talking about when you're starting down this journey, IP can be really intimidating. It can be complex, but I really want to tell everybody it's an absolute learnable skill. None of us go to school for a degree in intellectual property. Both Niraj and I have obviously learned over time. My degree's in engineering. And I didn't really know anything about intellectual property when I finished my degree. So it's a learnable skill. And where I'd like to start our dialogue today is really talking about how to get started, because I think it can be a real stumbling block for companies. And I think we talk about a little bit, we call it blank page syndrome. So you want to get started, but you don't know how. And I thought maybe I'll sort of give my 2 cents worth and then throw it to Niraj. But when you're getting started, I think instead of really focusing on the IP rights and what you need to start building, obviously everybody starts their company with a plan to create value. You have a business proposition, a place where you're really going to fit into the marketplace, where you think you've got your new widget or process that can really be a game changer. And I think really focusing on delineating that value and having sort of documentation and brainstorming around that initial value proposition is incredibly important. And I think that comes more naturally to lots of people, rather than fixating on what IP you need to build to protect it, in terms of really just delineating, well, what do we think really sets us apart? What is that value proposition? What is that small little piece of my process or my business that really sets me apart? And your ability to be able to really communicate well on that when you're working with experts can be a game changer, as opposed to a more traditional approach, which is sort of, taking a detailed listing of how your process works or all the basic components of your widget that you would use to put together and build it. When you really start thinking about what are the pieces that set you apart, it can be a great place to get started when you're thinking about your value proposition. And I know Niraj, Attabotics has really started, with a small portfolio, really building, IP around that value chain. How did you guys get started when you were looking to start building out IP assets around your business?
Yeah, absolutely. Thanks, Erin and Jen. When we started working towards creating IP portfolio for Attabotics, as you rightly mentioned, the fortunate part was we, from the very beginning, decided that IP is going to be part of the core strategy. And that's how we started doing things. It was not just a number for us, that how many patents we have filed or trademarks we have filed. So first set of patents, and that's how we started looking into 3 important components for our building our IP portfolio. One is categorizing whether IP is adding the revenue. Second is valuation, and third is partnerships. And these were the 3 major components for us. And we started looking into all those strategies around, are we looking for building or increasing our revenue using those IP portfolios, or partnerships and valuation. That's why right from the very beginning, when first set of family of patents we filed, we were more on the technology side of patents. And the reason for that was because we were at that point of time looking for validation of our technology. We were not at the growth stage. So it was more about, okay, we'll go to the companies and they'll say, you know what, we would love to collaborate with you and use your technology to understand whether we can enable and implement, but is your technology protected? Because we don't want to utilize your technology inside our supply chain without having some kind of a security. So our first set of strategies were towards solidifying our technology patents. But then the mid stage, when we started having bunch of clients like Nordstrom and Canadian Tire and bunch of other clients, they were really looking into, how can we have more growth towards different kind of domains and industries? And that's where our product portfolio started coming in. We started looking into, building the product patents. And that's when we started having application patents. And then the third stage, which is the current stage where we are a large organization, a scale up, it is more about partnership led growth, because we predominantly are in Canada and US in terms of the clients. But now we are growing in Europe and Asia. And that's why we feel that partnership led approach, if you have a patent portfolio in a way in more international demographies, then what happens is that your partner will be very happy to collaborate with you, because they also want to look into those IP portfolio and strategies. So, the way we have grown, and that is what I would suggest to everybody, is understand your motivation, understand what's your ask, and then also understand, what kind of a stage you are in, because every stage has a very different kind of a, strategy. And another important point is, since IP is a very time bound, kind of a strategy and a process, you also need to start looking into not just for first 12 months, but also next 30 months of the growth of the company. So from that standpoint, Erin, I know that you have worked with large organizations and would want to understand, because whenever we start working with large organizations in terms of partnership or co-building of the product, because we are at that stage where we are collaborating with Microsoft and Accenture, it becomes important for us to demystify the motivation of large organization and what they look at. So if you can throw some light around what exactly large organizations look at when they want to collaborate, or when they are inventing, what happens over there?
Yeah, that's a great question. So I worked in a large oil and gas corporation, and I've worked in a startup. And one of the things I think for everyone to be thinking of was, when a big company when you want to start having partnerships with them, they're going to go back and do some due diligence around what you've sort of put in place for yourself, but they're also going to look around the marketplace to understand what else is out there. And that goes back to that original point, is really understanding what your value is from the get-go. And I think Niraj mentioned, they started with technology-based patents. They really looked to cover the foundational value of their technology holistically. That was their starting point, and making sure you've really covered that initial value proposition that your technology has in place, and being able to demonstrate that to your partner is really critically important. Not just saying I filed 5 patent applications, as Raj and I have talked many times, like that the number is irrelevant. You could have 100, and if they don't align with your value and what really sets you apart, they're not relevant to the big corporations. So really being able to demonstrate, and when you walk in the door, be able to say, we filed 2 patent applications. We believe we've well protected this like cornerstone of our technology. Here's how we've tackled it. And then tell them what your roadmap is going forward. The fact that you understand as a small company that it's not like a one and done approach, that, you're continually building and you have this roadmap to protect your technology. You don't have to file on everything, but really explaining to those larger corporations when you're looking for funding or partnership that you have a plan going forward, I think is critically important. And it gives them a degree of comfort that you understand your space, you understand how to step forward, and you have a plan. It's not, it's not just I've done this and I'm finished and now I'm, looking to leverage the initial investment I've made. Your IP strategy needs to grow as your organization grows. And I think that's what Niraj was talking about, right? They started with protecting their core technology, and then they started looking as, their business was expanding. Well, where is my technology going to work? What are the different applications? Maybe it's in my space, maybe it's in other spaces. How does it integrate? What does my roadmap look like? Where are we going to manufacture our technology? Who's going to utilize it? And so then start thinking jurisdictionally. But you don't need to think about all of that on day one. And if you can really center around capturing that value proposition and build from there and have that roadmap and know you need to go there, you don't have to have an answer to all those down the stream questions. But the fact that you've considered it, I think, is a huge value add that you can show to larger companies when you're looking to collaborate with them.
Erin, I have a question over here. When you start talking to the large organization, generally startups and scale-ups are scared that their IP will be stolen, if you will. Like, that's a kind of a fear because you have a large organization with unlimited resources and everything. So when you start talking to the large corporates, be it partnerships, be it licensing or whatever, what are those important points from the IP standpoint, which can play a very important role? And what are your suggestions in terms of how do we define that initial set of partnership?
Yeah, that's a great thing to keep in mind. And I think that can really, again, it can center back around your culture and how you've started developing IP within your organization, making sure that there's an understanding of how you've captured your assets. Are they all, and what's your brand? How have you captured them? Is it in a patent application? Have you developed a trade secret around it? And really have an understanding that's well known across your organization before they start entering into these dialogues. What can we share? What can we not share? What do we want to tell them about our roadmap in terms of not just what you filed patent applications are, but how your roadmap plans to protect it, and showing them that you have a layered approach, but that you won't be talking about everything, I think is really important. And then making sure you understand when does it become necessary to start looking at agreements, to wrap around those discussions when you're having sort of, an initial touch base. Is this a fit? Is it not a fit? Whoever you're talking to is probably really unlikely to want to sign an NDA. So you have to media yourself. You have to train your staff, that whoever's having those discussions, to understand how far can they go to talk about your technology, and then when do they need to stop and sort of, look at, if you want to move things to the next level, here's what that looks like. And it's really, again, it's a tiered approach, understanding that you want to protect yourself, but you also, I think it can be a bit daunting, because of course, whoever you're looking to collaborate with, and when you're the small guy, there's this real desire to attract funding or partnerships and all these pieces, and they want to ask you, and they're going to ask you everything. But just because they're asking you doesn't mean you have to tell them everything. And sometimes I think you can sort of give them a picture of your roadmap and tell them how far you're willing to have a dialogue, but make sure they understand you have limitations. Because again, I think that gives them confidence that you understand that there are limitations. You understand there are things you don't want to disclose, and you're not just sort of jumping down the rabbit hole in terms of just wanting to tell them everything, which I think there can be a real bias to, you really want to attract the partner, so you want to tell them everything, but understanding that that's not the best case. Niraj, what's the approach that your team has taken when you're sort of, especially in these larger partnerships that you just spoke about?
Yeah, and it depends, because our partnerships are based on either technology-led partnership, go-to-market partnerships, and a sort of a co-building partnership in terms of products, not just technology. So, for example, take the example of organizations like Microsoft. When we started working with them, based on our technology and a specific area in micro fulfillment, we started taking their help, and then very quickly we realized that we are a very good applied platform for organizations such as Microsoft and other organizations. And then we started talking to them, thinking about how we can have a lot of other areas which otherwise we will not be working on, primarily in like AI, machine learning, and predictive analytics, because Microsoft has this huge team. And we started thinking about if there are possibilities of joint co-development and stuff like that. Similar thing we did with Alberta-based AI ecosystem called AMI, Alberta Machine Intelligence Institute. So there were areas where we started working on the tech side of it. A bunch of areas where we do development. Like, for example, with Accenture, we have done something in e-grocery, and we are actually developing a kind of a joint product in e-grocery and fulfillment. So there it's a product partnership. And Accenture is also kind of with us on a joint go-to-market. So the point being, in areas where we do understand that there could be innovations involved, we are very clear about what we want to have as a portfolio, and very clear about what can be the joint IP. Or what you call it as forward IP. But in the areas where it's more about partnerships, and that partnership could lead to further innovations, we are clear that we will have those discussions probably 1 year down the line, and we'll be very open to that. So we involved the decent kind of lawyers who were able to draft the kind of agreement that indicated that kind of approach. So yeah, as you rightly mentioned, the important thing is we write our strategy, and we are very transparent when we are partnering with these partnership or big companies, telling them what exactly our plans are, and that helps us communicate to them better. And that helps us at the very beginning, because then after some time, you will come out with very new set of things when you're growing. See, the problem is not about when you are not doing good, because when you're not doing it, you're trying to find out all possible ways to work, ways to make that partnership work. But the problems start happening when the partnership is really flourishing, because at that point of time, there are so many things that you can achieve from the IP standpoint, strategy standpoint, and that's when you need to be prepared for it. And that's why, from the even strategy standpoint, we keep inviting, and as you also indicated, IP is also a kind of a teachable skill. And our, kind of executive team and senior managers, we time to time invest, time and effort to ensure that they do understand the entire strategy around IP, and a bit of an IP tool as well, moving down the line, because if they understand those IP tools, then it helps them to even communicate with us as the IP sort of a department. And that's something which we do it on a monthly and quarterly basis. With that, one important aspect, you're part of IAC, so I do understand that you're building this pool of portfolio. So a lot of times, companies do not have that access to that large IP pool, and it is difficult for companies like us, or many of the participants might be representing the company which might be small. They don't have that much of resources, and if they want to have access to those kind of a licensing, or they want to have access to that IP portfolio, how do they talk to you?
Oh, great question. Yeah, so part of IAC is really about the strategy and enabling companies, but part of it is recognizing that, yeah, as you're a startup, it can be really daunting. And I get that question all the time from people, like, is it even worth filing if I only have so much money? Like, how could I possibly defend against a huge entity if they come after me? And one of the things that within the data-driven clean tech space, IAC is looking to put in place is this defensive portfolio that companies will have access to, that can just be part of their strategy when it comes to risk mitigation, and understanding that it can be a tool that's available to them if, in dealing with larger competitors, and trying to make sure that they can access these potential portfolio assets as part of their overall strategy. It is something we'll be doing a webinar on in the fall this year, talking a little bit more about patent pools and how they come into play. But I wanted to chat about, in addition to when you were just talking about building out your culture and training your leadership team. And I think, when you're going into these discussions and where you can be a partner, that there's so many options that can come out of these partnerships. And really, again, understanding the strategy for your company and where that value is for your company and what your plans are can be really important. It's not that it can't change, but making sure you're always going back to it, because I think, especially as the small player that's entering into a larger relationship, it's important to always circle back to understand what's our strategy, what's our plan, where do we really need to, because Niraj, you mentioned joint ownership and other ownership. So where do we really want to be the true owners of our innovation? And so we can really leverage those pieces. And where can we be flexible? Where do we have the ability to maybe pivot, or it's less important that we have this ownership position and we can have an understanding. I think that all goes back to spending the time thinking upfront about what's the goal? What's the goal of my company? What are we trying to drive towards? How are we going to drive revenue? And yes, that can be continually building and expanding, and making sure every time you're looking at, the assets you're building, the portfolio you're building, you go back to that strategy, you go back to what the value is to your company, and ask yourself, if I invest the money in these assets, is it going to help me down this path? Because I think it's really easy, especially as your company's growing. And if you build this culture and there's lots of inputs flowing into your group all the time, and lots of different ideas and concepts that you can look at protecting, Nobody has an unlimited budget, not even the big guys. Nobody files on everything. And so making sure when you're making those decisions that you understand the alignment of the assets as you build them back with your strategy, that you understand how they fit in, is critically important. And I wanted to actually ask Niraj a question. So as a company grows, you could start off developing IP assets that maybe your company's pivoting along the way. Maybe those assets have less value. Maybe you had a brand line that, you know, you're not really interested in anymore. In my experience, it can be really hard for a company to want to let go of anything that they've invested in. And there can be this real desire to be like, no, I need to maintain everything. But unfortunately, the costs associated with intellectual property assets grow over time. It's not linear. It's exponential. So your costs are going like this. How do you go back and continually revisit the portfolio you're building against that strategy? Do you guys go back and do it often? You know, what's the attitude around potentially culling or letting some of those assets go or looking to divest them into other players?
It's a really, really good question. And we kind of every single strategy, revenue line and the growth line, we connect our IP portfolio to that. It's very important for us not to just say, oh, we have 100 patents. We actually, to be very frank, have only 14 patents filed in multiple jurisdictions. But if you start comparing us with our competitors, we are probably one of the strongest in the world, actually. I had the last time when you mentioned about like number game, it's not a number game, as you rightly mentioned, and that's what we follow. But very important part of our strategy is always all this IP portfolio, especially the application patent, because core technologies, you know, you probably have, you will maintain it over the course of whatever time period you will be running your organization. But application patents, the moment your strategy changes, your business strategy changes, your application patents may not be relevant. And that's the reason why every single patent and or multiple patents have to be attached to one of the strategies on the revenue, partnerships, or valuation. As I mentioned, that these are the three important criteria. And we have to map that. The moment any of the patents are going out of it, we kind of don't want to maintain it or manage it further. And that's where a bit of technical terms, as a lot of people may not know this, provisional patent and PCT application before, and you can opt for that. So what happens is we file for the concept patents or the patents at large and the provisional, and then that gives us a good 1 year of a time to think through what can be done further. And then we always convert it into PCT application, patent cooperation treaty application, because that allows us to have good 30 months of a time to think through what exactly could be our strategy globally, because patent is not just in a particular country, but you start thinking about creating a global portfolio and managing it is a costly affair. So good 30 months is a good time for us to start looking into that. But frankly, as you rightly mentioned, some of the patents we had to just let it go. I mean, even at the office action stage, we knew when our attorneys were saying that, you know what, you will get a patent. Tag along, and we're like, no, this is not part of a strategy. And even if we would have done it, we would have donated it to somebody else, but it would have been donation. It would not have been something which we want to just have it for the sake of having it. So yeah, you are right. There has to be a strategy, and that strategy has to have those IP components intact with those strategies, because scale ups, even for us, you know, our board of directors as well as investors ask how much money you're investing and why you're investing this money on IP and how will you sustain it, because filing is one thing, but prosecution and the maintenance could be a daunting task. Are your views, Erin, on this?
Yeah, I would similar. I think especially when you're talking to funders, your board and all that stuff, they really want to hear you talk about how you have this continued alignment, how you revisit it. And I think when you start building out that IP culture within your company, when you start, doing your staff training, making sure the company understands what the strategy is, not down in the weeds, but they understand what the goals are, where the important pieces are. And then it helps with these decision-making pieces. I love that you said, Niraj, your patent attorney will tell you, you can get a patent. It's true. You can probably always get a patent, but does it actually help your business? Sometimes you'll start off with maybe a really broad set of claims that get narrowed over time. And then you have to continually ask yourself, do these in the state that I can actually get them issued, still have value for my company. And so I think getting used to at the early days, like at that outset, when you start sort of building that culture and building those decision valuation frameworks in place, it's really so much easier to grow and scale when you've sort of built that foundational piece in the early days, and then you sort of expand over time. I think I told Niraj, it was a while ago, when in my last role, I was at a large oil and gas company, and I got a couple questions when I first got there, and people were like, "It's great, you seem really nice and really smart, but I don't understand why you're here. Like, but you know, we produce oil. It doesn't matter." And I think that's a really common viewpoint in the industry, maybe 10, 12 years ago, right? But what I think what all startups need to know is intellectual property and building a portfolio of assets. It can always, it's not unique to a sector. It's not just in the pharma space. It's not just in the clean tech space. You can always look to build value when you really look to understand your organization and understand what they are. And yeah, for sure, like the big producers, the big pipeline companies, that their primary goal and revenue stream can be around production. However, there's a whole bunch of nuances that go into how that happens and how the process is more sustainable and how you're dealing with, emissions and ESG and compliance issues. And you can build a portfolio of assets around that technology that make you more competitive. And so I think when you're thinking about your value proposition and building that, if you build that culture within your business and build a basic understanding across all your business units, far beyond just R&D, to understand intellectual property is more than just technology. It can be more than just protecting technology. You can really get these other assets that start flowing into your group as opportunities to see how those tie into your business. So I think, Niraj, you said with technology patents and you go with application patents. How do you get your whole company engaged, though, in that culture? I know you sort of revisited that you talked to your executive team and stuff, but how do you make sure that you have that engagement beyond just maybe your core, R&D group, which are usually a little bit more familiar with IP?
For sure. And Karen has a question. After this answer, we probably will take that up. So I think this is a very important part, because when we were like 20 people, it was easy to communicate. We are now 350 people. And out of 350 people, at least 320 odd people are directly or indirectly connected to the IP. For example, our field service agent, who actually is managing the entire structure, has had a lot of ideas, and very good ideas, insights, because they are like first point of using our structure. So what we do is we have created that kind of a team discussions, wherein any IP which is being presented, at least that team has to be part of it, even if a lot of people may not be part of inventors team. But if that vertical is involved, we want them to be involved in those discussions, and we make it very transparent from standpoint of whether it is innovative, but more importantly, whether it aligns with our business and strategy goals. So over the period of time, we have invested and have made this transparent process where we are communicating with all level of employees about why we are filing this patent, what was the reason behind it, and what was the strategy behind filing those patents, and make it very public within the organization. And that has sort of helped us create the kind of a DNA within the organization where these people come to us, they ask those questions. Even students who have just recently joined us do come to us asking, why did you do this? And it's very important for us to invest that time with those individuals and collectively with those teams, because this is a good investment for us. So it took us 1 year, good 1 year, believe me or not. And during pandemic, it was easy to communicate because we didn't have to, manage everything like physical location and stuff like that. It helped us invest. And last 1.5 years, we have been just investing a lot of these intellectual information and the strategies to all our team members. So that's what we do. One question, which is from Karen.
Erin, yeah, I was just going to say to you, Niraj, is what people are thinking about when they're filing the patents, and sort of when is it sort of at the idea stage, a mid-process, upon finishing, sort of some of the insights around that.
So one important thing, which is more technical in nature, but it is very important for everybody to know, is there is something called public disclosure. Because if you do a public disclosure, many of the countries, you lose the right to file the patent. And in many of the countries like US and Canada, you have only 1 year of a time. So it's very important, apart from understanding when should we file, if you have already disclosed it in public. And what that means is if you have exhibited it in any of the conferences, if you're talking to the prospective clients where there could be agreement in terms of financial, kind of buying and licensing or anything of that sort, even if that is not in public domain, it's also treated as being going in public. So important aspect is whenever you feel that you are interacting with the outside world, outside business environment, you need to start thinking about filing the IP if you have any IP. Second part is, when you have a concept stage, and it is most of the countries do go into first to file patent versus first to invent. And I don't want to go into those nitty-gritties, but the point is, if hypothetically 2 companies are doing the same kind of invention and they have not gone in public, whomsoever files first gets the right to file the patent in other countries as well, including the country where you're filing right now. So if you're at the idea stage and if you feel that you have decent understanding and idea about how you want to take this product or a technology forward, there are tools like what Erin mentioned, that you need to invest some time to understand a bit of tools, because that can be part of the strategy. Like provisional patent application. The provisional patent application, you have to file it only in one country. And it is enforceable in all the WIPO countries. I think there are 142 WIPO countries, member states. Only by filing one country, and you don't need to be precise because you're not drafting the claims sets. You're just drafting, you're sort of buying a land. And now on the land, you can do whatever you want to do, whatever you want to build. So the point is, you secure your land by filing that provisional. It gives you good 1 year of a time to exactly do whatever you want to do in terms of innovation. And you can file multiple patents in multiple countries with the priority date of your provisional. So this is a very strong tool because you get a patent pending status. You can freely start talking to anybody you want to talk to. And then within 1 year, you can decide if your patent is very much restricted to just Canada or US, file it in those countries. But you feel that no, you still feel that, it's a partnership-led approach and we probably would want to grow it across the globe, then convert it into something called patent PCT application, which gives you additional 18 months of a time. So these are the tools. If you can learn about it, it will be helpful for you to utilize it. You are not gonna do most of the work. Your attorney will do most of the work, but at least knowing that will help you communicate and build a strategy. Erin, your suggestions?
Yeah, I think that's a great point. So when you're thinking about filing, I think Niraj is right. It can depend. Public disclosures come into play. I also think it's really important to keep in mind of if you have regulatory restrictions within your industry, is there a requirement to disclose to a regulatory body? What does that disclosure look like? If you do, if you're going to a conference like Niraj said, like factoring that in can be really important. The other piece I'd like to add is I think understanding the pace of innovation in your space can be really important when it guides you when you need to file. If you're working on tackling a problem that everybody has and everybody's working on and you come up with a solution, you might want to look at filing that more quickly versus if it's a really nuanced solution that maybe it's a problem you're looking to solve that's come up, but you're much further down the road than everybody else. The urgency might not be there. But the thing to keep in mind is you have to be, whatever you're filing on, you have to be able to describe it in enough detail that it meets sort of the basic threshold that's out there, which is you've got to be able to explain it. Not to anybody, not to necessarily myself or Jen or Niraj, but to someone of skill in your space. You have to be able to put enough detail in there that it would be understandable to them. But I think Niraj is right, understanding the tools, not necessarily the intricacy of the tools, but what tools are out there to allow you to do cost deferrals, what tools allow you to file, like Niraj mentioned, a single application that could maybe be filed in multiple jurisdictions down the road so you can defer the costs. It can be really valuable. I think there's a great question from Mark that flows into that, Niraj, and it's really about assessing the development. So understanding when do you file, and there's idea mid-process, but then there's also this process of how do you go about looking at all the different options you have to file on, how do you identify those concepts? And we talked a little bit about culture and making sure the organization as a whole understands innovation and intellectual property and those value-added pieces so they can flow in. But when you have them in there, how do you go about assessing those developments and sort of keeping those connection points and identify, what could be of value to the company?
Yeah. Number one part, what you mentioned, and Mark had the similar question, was, IP assessment. Number one, we have compartmentalized a lot of things in terms of the teams. And those teams, first of all, do discuss about the frame. So we have discussed about and told all the team members that when they are talking about the innovation, they need to talk about, okay, how does that impact to the technology, product, and overall strategy, if they can talk about it. One of the biggest challenges, and you would be surprised to know, was that a lot of people didn't want to come forward because they didn't know how to express the entire invention. They were very scared about it. And we told them, no, you're not writing an article. All you need to do is bullet points, hand sketch drawing, or even a short video. Just upload that video, and whatever discuss that and express that. So that became a very important strategy for us, because the moment we informed that kind of a thing to everybody, guess what? There were so many people who wanted to express, kind of what they think could be unique and novel. Though we had all of a sudden had like 70 odd concepts, which was difficult for us to manage. Then we started, including the managers telling that, why don't you become the first line of screening for us to give us the better inventions, which essentially could be important for us to look into. And then we always go for prior art search, and prior art search or patentability analysis is a very optional step wherein you can find out strength of your innovation from the current IP portfolio filed by other companies. So we always go for a prior art search, and you will be surprised why it became very important. 3 aspects. Number one, it was always to find out whether our invention is strong enough to file. But the second aspect was a lot of investors and our partners started asking for prior art search, not the clearance search or FTO. They're like, we are collaborating with you. Do you have any kind of a supporting document? And we provided them a prior art search report, and they're like, oh, this is helpful. But the third important thing was when we started explaining the same thing to our teams, our team was able to also find out a lot of new ideas because of prior art search. So that's the process we adopt. And if you have more suggestions, please feel free to include over there.
No, I think that's a great question to adopt. We used to call them, we tried to get IP champions within teams to have maybe a slightly deeper understanding to sort of champion and bring ideas in, because like you said, it can become unmanageable. What I think you want to try to get away from is, like Niraj says, don't be intimidated. We don't want people to be intimidated by the level of detail in there. You don't want groups to be self-filtering, I guess, on what they think is important. One of the things we used to hear all the time is something's just, it's just good engineering practice. It's not that exciting. And we're like, did you solve a problem? And like, oh, you solved a problem. Oh yeah, this has been a problem for decades, right? If you're solving a problem, it's really exciting. Make sure you're telling people about that. Groups want to hear about the problems you're solving. So I think that can be really important.
I've just to follow up on sort of what you both have talked about around sort of partnerships and what this means. There's a comment, but also spurs a question. The perspective of if you're having new partnerships and agreements in place, you're looking at sort of co-developing foreground IP. Based on your experiences, what are your thoughts, as organizations are looking to engage in these collaborative initiatives and this development of joint IP? What can this look like or mean, from a, prosecution, a licensing standpoint, these dialogues, this cultural sort of side of things that you've seen, if you could share with the audience.
Yeah, that's a great question. Maybe I'll throw something in there first, and then Niraj can add on. I think that the key to keep in mind when it comes to joint IP, and I see this confusion happen periodically, is joint ownership of assets can be complicated, but it tends to be complicated when you actually haven't thought about it down the road. But if you have agreements in place that can govern that carve out like how to do the direction around it, who provides the direction, what does it look like, because joint inventorship happens all the time, especially as a partner, right? One partner contributes one piece, another partner contributes another piece, and then how does that inventorship roll up into ownership? I think if you think about it up front, it can be a little bit easier to manage, whereas after the fact, again, if you didn't have a strategy or a plan around that, that's where you start getting into trouble. So I think for me, it often goes back to your strategy, understanding what's it important for your company to own, because it can create encumbrances in other business avenues, and what's important for your partner to own, so it doesn't create encumbrance for them, and try to approach it with an open mind and understanding. And then where you both need to have a degree of ability to maneuver down the road, really having an open and frank discussion around what that looks like. And you can carve out what that looks like by way of an agreement that can govern that joint ownership piece. So it doesn't need to, it doesn't need to be complicated if you do the forward thinking. And Niraj, I'm sure you have more to add, because that's something I'm sure you've encountered numerous times.
No, I totally agree. One important aspect which we have lately started looking into is, what if we get acquired? And during the acquisition process, if you have a joint IP, believe me or not, a lot of times if you have a joint IP, it's a good thing for investors. They're like, wow, you own IP with this so-and-so big company. The only thing which we have also started getting into is in case of acquisition of the company, what will happen? And that's important for from the standpoint of M&A, and that's something which we want to include and add in those agreements. But beyond that, we're always happy because our IP strategies around the product. So if there's a joint product with a particular company which we are going into the market with, IP portfolio is part of that product, and that's a part of the strategy. Which we want to look into from the product strategy standpoint. And that's why we are not scared. We are always happy if the organization is looking into it. And we always mention this thing. A lot of companies like us are the best applied platform. So a lot of companies would come to us saying, you know what, we want to work with you because you're a very good product and technology where we could apply in a different domain. So there will be a lot of application patterns that will come because of that. And we are okay with having joint ownership. So that's a part of it. There's a question which I saw was, what are the other forms of IP in scaling the organization? And I just want to add a bunch of things. Patent is not the only thing. You can have design patents if you have a hardware and different kind of designs which may be unique. So you could talk about design patents. Trademark is a very strong tool because, you don't go to any of your colleagues or relatives telling, you know what, you should have this medication because there are 700 patents around it. The fact is, patent, is for competitors, and trademark is for your clients, because that's how you will know. So patent reduces the competition. And then because of that, your trademark solidifies. A lot of good companies, their core patents are already gone because that 20 years of lifetime is gone of that patent, but still the trademark became so strong. So trademark is another very important aspect which you should look into. Copyrights are generally very straightforward things. If you have a software or if you have any specific designs, you could look into copyrights. But yeah, you are, as Erin had mentioned right at the very beginning, that, and Jen had also mentioned about that, IP is a strategy. If you understand the tools, you don't need to get inside how to draft the claims, but you need to understand how the claims can play a very important role. Then you can start using these building blocks to create a strategy for your company.
Yeah, I think that's a great point, Niraj, in that, sorry, a strategy isn't just about patents or trademarks. It's about your collective value and how you're looking to protect it. And it's a great example. Patents expire over time. Trademarks have the ability to last much, much longer. And so, and no client goes to, or no consumer at the end of the day goes to buy your product by like, oh, I'm going to buy this one. Like Niraj said, it has lots of patents. You go because you have brand recognition. You know who they are. It stands for something. And so really making sure you have a plan around your brand can be critically important. And I would suggest often when people are getting started, when you're getting your company off the ground, the first piece of IP that you really develop for yourself without actually thinking about it is your name. because you usually come up with the company name. And having a little bit of understanding around trademarks and how that can happen and your name and the field you're going to practice in, it can be really important because, you start showing up and building out who you are in the marketplace. And, that name you selected, you don't want it to cause you problems down the road and then have to change, that sort of 2-3 years in when you've actually started building that brand out. So it can be really important, but to build that out holistically, is really key. Patents are the most expensive of the types of IP rights. So if you have a plan that can protect all the different types of rights, and that would include trade secrets as well, even though it's not a formal right that you register, at least not in Canada or the US, really in most jurisdictions. But having a plan to understand that you have a plan to protect secrets, how you go about identifying those, what those are within your business, also really important. And it all goes back to that strategy of what's the value of your company, and then what's the optionality around your different mechanisms for protecting those pieces and what makes the most sense. If you've gone through the exercise of thinking about the value that your company has, then you can really engage with an expert who knows how to get into the weeds and draft claims and understands the bits and pieces. They can help you identify the best avenues or the options you have to protect it. But really, to get the most out of those experts, you want to have done that early stage thinking for yourself.
There's
think
a question.
Oh, go ahead. I was going to say.
There is a question, Jen, which is very important question. I thought we should discuss about that. Somebody has mentioned that, let's assume their product is infringing a previous patent. Can they little bit tweak to make it unique or novel, or even come out of that infringement? And my only answer that will be that if you're infringing any patent, and patent attorneys are very intelligent people, they know how to write a broad set of patents and the claims. So the important thing is it's not just very simple tweak which will help you come out of that infringement if you feel that there is some kind of an overlap. And if that happens, go to that patent attorney, ask him or her to explain the claims in a more layman language to understand what's the scope of that patent claim set. Because if you understand that, then you probably will be able to understand how much changes you may have to, kind of make in order to, come out of that overlap. And that overlap changes is not just a small tweak. It generally is significant amount of work involved. Erin?
Yeah, I was going to say the exact same thing. I think when you get those draft claims back from your agents and stuff, it's really important to make sure you understand what's in scope and what's out of scope. And again, you don't have to be an expert in drafting them, but you want to invest the time to have a degree of understanding around how to read them. What does it mean to you? And I would also suggest, if when you're reading them, you have a really hard time as the expert understanding what they mean, you want to tell your expert to help you, because if you're struggling to understand them and what they mean, then your patent examiner could have the same struggle. You want them to have a degree of the ability to understand them, to that personal skill in the art. The other thing I would suggest is, it goes back again to that value proposition. When you're thinking about your company and what adds value and what that first draft looks like, really going through the exercise to understand what are the most critical components and where could something still work, maybe not quite as well, with a plug and play and a switch out of something else. And if you sort of go through and ask yourself those questions as you're sort of looking and reviewing your draft, and you really question, would this still work if somebody used something else? Would this still work? I like to call it like stressing the boundaries. If you go through that exercise, then you can really help expand your asset to make sure it covers as broadly as possible and really focuses on those real value pieces that set you apart, versus just a list of all the components that are part of your product at the end of the day. Because I think, as a technical person, and my background's in engineering, when you're describing something and you're describing a new product, you talk about all the pieces of it, right? It's got to have this, it's got to have this, it's got to have this. But when you're thinking about a patent, it's a different conversation, and you can describe those parts that can be used sort of interchangeably one way, and then really focus on centering your protection about the part that can't be interchanged, that real solution that you've come up with. And you want to make sure you're thinking about that when you're reading your draft back from counsel, when you're working with them and framing it in the first place. And that helps the ability to not allow someone else to sort of do that minor tweak and get around your claim, because you've already thought about it. You've already thought about the easy workarounds to your own invention for other people. So I think you always want to review things too with that critical eye. Think of yourself as view your claims as a competitor, and then take a look. And if you were trying to work around it, how would you do it? And make sure as much as possible you try to incorporate those, and then it can avoid that ability to work around quickly. That was a long-winded answer.
Jen, you were saying something.
Yeah, it's so just kind of, I guess, tying in as we are wrapping up here is, a lot has sort of been talked about around, the importance of these conversations, and, really sort of having that, transparency and that dialogue. And, what you both have really, fleshed out here is, the importance of, that expertise, and both of you on your journeys have gained it, in different ways. And so maybe as we're closing here, is if you could share a little bit more around, what has that experience look like for you as somebody sort of thinking about, how do I approach these conversations? Where can I start to gain some of this expertise if I want to start on this? And also a little bit more around some other best practices for guidelines when you're wanting to work with an expert and you're unsure of, how to have that conversation, maybe to kind of close us out.
For me, it started with my professor in Sweden, who started asking me to go through patents. It was a painful process. I'm like, I'm doing a tech degree, and what do I have to do with the patents part of it? But the fact was, I was able to be part of a lot of these kind of conversations where it was not just a very strategy, but also a bit of IP from the standpoint of understanding for a business person or a technology person what exactly is required when you're talking about IP. So I had gone through a lot of videos and YouTube videos, and had gone through a bunch of books as well before becoming like a full-fledged patent professional, where I actually started drafting patents simply because I liked it. I'm a technologist, and I feel for the technology people it is easy to understand law versus the other way around. That's my assumption, and I might be wrong. But important aspect is go through a lot of documents and the video and articles which are there in the public knowledge. Understand those tools. It's easy. I'm sure that IAC does a lot of these kind of workshops. Be part of those workshops. That is the very beginning of your conversation. And then the second step is find out a good mentor who is IP attorney, but who is also a strategist. Whenever we start hiring any of the IP firm or IP attorney, it's important for us to ask questions which are related to the company rather than technology. If they don't understand our company, don't understand our motivation on why we are doing it, no matter what, if the attorney has a double PhD and a best patent attorney, it doesn't matter to us, because he or she won't be able to understand our motivation towards building that IP portfolio and the strategy. So we always explain what we are trying to do from Attabotics standpoint and the company standpoint, and then ask questions from them. If they're able to answer those questions and able to include that, then the next layer of things are, okay, what kind of patents you have filed? Have you filed patents in mechatronics or supply chain and AI? That is the next, I guess, level of things. But when we were early stage, we also were looking into also cost-effective processes. So we are also talking to a lot of attorneys who essentially work with startups and whose charges are not like $1,000 an hour or something like that. Erin?
Yeah, I would agree with all those points. I think that the key to keep in mind when you're choosing an expert is, I completely agree. It's not just about your technology. Lots of it can be about what works for you. Does this person work well in your style? And there can be lots of different experts out there, but be confident and find someone who understands you, who can meet you where you're at, and who can be part of your journey. Because as your company grows and scales, if you're successful, it's almost like a marriage, that you've got to have this person who's going to grow with you, and you have a good communication style, and who you feel you can work with really effectively. I think it's critically important, because you need them to understand your business. their background doesn't matter if they're not interested in understanding your business and where you're going and providing you with really good advice. And I would say, don't be afraid to interview a bunch of experts and pick the one that works best for you. I think is really critical to understand. And I think that the last point I have is that as someone who works in your company, if you're the IP lead, and you need to be the champion for your company. You can't just outsource IP strategy. You can't just throw it over the fence and say, hey, can you build me a strategy? You have to invest some time yourself in understanding those value propositions so you can properly communicate. And then your experts can help you execute on that strategy and help you continually revisit it. But it requires an internal investment of time and money. So money alone isn't going to get you where you want to go. You've got to build in that time and spend that time, as Niraj said, learning and getting up to speed. You don't need to be an expert, but you need to understand what questions to ask.
Thank you so much. And now, Annika, I'll turn it over to you.
All right. Thank you so much to everyone for attending today, and a huge thank you to Erin and Niraj for taking the time to share their expertise with our members. I know, given the questions that were asked, it was really valuable for them. As a reminder, we will be distributing this recording following the session. And if you have any follow-up questions, please don't hesitate to reach out to us as well. So thank you, everyone, and hope you all have a great rest of your day.